Welcome to the deep dive. I'm really curious today as we jump into a topic that, well, it touches so many of our lives directly.
It really does.
The often complex, sometimes challenging world of tenant rights and, landlord-tenant relationships. You've brought us an incredible collection of sources, including this thing called The Ultimate Guide to Tenant Rights, Unmasking Landlord Tactics.
That's a good one.
And our mission today really is to arm you, the listener, with what you need to navigate what can feel like a total minefield sometimes.
Yeah, minefield is a good word for it. Yeah. Navigating these relationships, it can be incredibly complex.
Right.
And unfortunately, some landlords do resort to tactics that flat out violate tenant rights.
Okay.
So this deep dive, it's about giving you the essential knowledge, the tools, really, to recognize these actions.
And fight back.
And, crucially, understand how to protect yourself. Think of this as maybe your shortcut to being properly informed about your legal rights, your responsibilities, especially as a tenant here in California.
Okay, California specifically. Good. So, with that complex landscape in mind, where do we even start? How do we arm ourselves?
Well, it really all starts with the basics. The foundational protections you're entitled to.
Foundational protections. Okay. Like, imagine someone, let's call her Sarah, just moved into her first place in LA. What's her first line of defense?
Right. So Sarah, and honestly, every tenant in California needs to get a handle on the fundamental laws. They're there to ensure fair treatment, a safe living space.
Makes sense.
The big one, number one really, is your right to a habitable home.
Habitable. What does that actually mean legally?
Well, the key thing here is that it's not just about, comfort. It's a legal mandate. Landlords are legally obligated to provide a safe, healthy living space. That means it's got to be free from hazards.
Like mold. We hear about mold a lot.
Exactly like mold or pests,
Right.
Faulty wiring, lack of heat or water. If your heat goes out in winter, that's not just inconvenient. It's potentially a violation of this right.
Got it. So the physical space is key. What about your personal space, your privacy?
Great question. That's the next big one. Your right to privacy.
Yeah.
It impacts your daily peace of mind.
Totally. What's a common mistake people make here? Something landlords might try to, exploit.
Well, a lot of tenants think, the landlord gave notice, so they can come in.
Yeah. Isn't that how it works?
Not quite. The crucial detail is, generally, landlords can't enter your unit without proper written notice, usually 24 hours, and your permission for non-emergency stuff.
Written notice and permission.
Right. The only exception is, like you guess, a real emergency. A fire, a burst pipe, something serious.
Oh, okay.
Otherwise, an unannounced visit isn't just impolite, it could be a violation.
That difference between just notice and needing permission, that's huge.
It really is.
Okay, let's shift gears slightly. Protection against discrimination. This pops up in the news constantly. But what's maybe a surprising part of this?
I think what surprises people is how broad these protections actually are now.
Broader than you'd think.
Definitely. So discrimination is illegal based on the obvious things, race, religion, disability, but it also covers things like family status, having kids, or even your source of income.
Source of income? Like how?
Like using Section 8 vouchers, the federal housing assistance.
Right.
A landlord generally can't refuse to rent to you just because you use a voucher to pay part of the rent. That's a protected source of income in California.
Wow, okay. That's a really significant layer of protection.
It is.
And finally, for California tenants, something you mentioned is a real game changer. Just cause eviction protections. You said this was really big. Why? What's the core shift here?
The core shift isn't just that landlords need a reason to evict you after a year. It's that the law fundamentally flips the burden of proof. Meaning the onus, the responsibility, is squarely on the landlord to prove they have a valid legal reason for the eviction. It's not on the tenant to prove why they should stop.
Okay, so after 12 months.
In most covered units, yes. After 12 months, they need a valid just cause. And these fall into two buckets, basically.
Which are?
At-fault reasons, that's stuff the tenant did, like not paying rent, violating the lease, causing damage,
Right.
or no-fault reasons.
Yeah.
That's more about the landlord situation, like they want to move in themselves or take the property off the rental market or do substantial renovations that require the unit to be empty.
Substantial renovations, okay.
Yeah, and for no-fault evictions, they usually have to pay relocation assistance too. But the point is, our hypothetical, Sarah, after a year, her landlord can't just say, I want you out for no reason or made-up reason.
That's powerful. Okay, so knowing your rights is step one. But unfortunately, as you said, that's not always enough. The sources talk about this darker side landlord tactics used to get around these rights.
Yeah, let's unmask those, because recognizing them, that's the absolute first step in defending yourself.
What's striking is you said they're varied but share a common goal.
Exactly. The goal is often to force a tenant out, make them leave, without going through the proper legal eviction process, which costs them time and money.
Right. So what's a big one?
A huge one, and maybe the most insidious, is harassment.
Harassment. That sounds bad, obviously, but what does it look like in this context?
Well, the tricky thing about harassment, the real insight maybe, isn't always just obvious threats. It's often this slow burn, this pattern of conduct that erodes your peace, makes you feel unsafe or unwelcome, even if each individual act seems minor.
So it's cumulative.
Often, yes. It can be things like frequent unnecessary inspections, showing up unannounced constantly, interfering with your quiet enjoyment, making threats, intimidation, or just generally creating a hostile living environment.
Is there legal protection against that kind of stuff?
Absolutely. California Civil Code Section 1940.2 specifically defines landlord harassment. And places like LA have even stronger local rules, like the Tenant Anti-Harassment Ordinance, THO. These give tenants a clear legal basis to fight back.
Okay, so knowing that definition is key. Then there are self-help evictions. You said these are flat out illegal. What's the most common way they try this?
Honestly, changing the locks. It's crude, but it happens.
Wow. Why risk it if it's illegal?
I think some landlords hope the tenant won't know their rights or won't have the resources or energy to fight it. It's a gamble on their part, an illegal one.
And it's not just locks, right?
Oh, no. It's any attempt to physically force you out without a court order. Shutting off your utilities, water, electricity, removing your front door or windows, taking your belongings out of the apartment. All illegal self-help tactics.
Unbelievable. Okay, what about something maybe less aggressive but still problematic? Like ignoring repair requests.
Yeah, that connects right back to that, right to a habitable home we talked about.
How so?
Well, if a landlord deliberately ignores necessary repairs or just drags their feet endlessly, making the place miserable to live in, that's not just bad service.
It's a tactic.
It can absolutely be used as a tactic, a form of constructive eviction almost, making conditions so bad you want to leave. It violates your right to habitability and can even be seen as a form of harassment.
Right. And what if you do complain? You request repairs or call the housing department. Can they punish you for that?
That brings us to retaliatory actions. And the answer is a clear no. No. Landlords cannot legally retaliate against you for exercising your rights.
Like what kind of rights?
Like requesting repairs, complaining to a health inspector or housing authority, joining a tenant union, testifying against the landlord, anything like that.
So if you complain about mold, they can't suddenly give you an eviction notice the next week.
Exactly. If they try, that eviction is likely retaliatory and illegal. It's a fundamental protection. Otherwise, tenants would be too scared to ever speak up.
Okay. What about the eviction notice itself? Can they mess with that?
Oh, definitely. That's another tactic. Improper or fabricated eviction notices.
How would Sarah, our tenant, know if a notice is fishy?
It really comes down to the details. Landlords have to follow very strict legal procedures for eviction notices.
Strict how?
The notice has to have specific information, correct dates, the right names, state a valid legal reason for the eviction, clearly. Even small mistakes can make the notice invalid.
Like a typo.
Sometimes, yeah. Or getting the notice period wrong, or citing a cause that isn't actually a legal reason. These flawed notices can be challenged in court. It buys you time, gives you leverage.
Good to know. Okay, what about money? Rent increases.
Right, unjustified rent increases. Landlords can raise rent, obviously, but there are rules.
What's the key thing tenants need to watch for?
Know the limits. California has the Tenant Protection Act, which caps annual rent increases for most units. It's usually 5% plus the local cost of living increase, or 10% total, whichever is lower.
Okay.
And many cities like LA, San Francisco, Oakland have local rent control laws that might be even stricter. Plus, they always need to give you proper written notice before an increase takes effect.
So check state and local rules.
Absolutely crucial.
Lastly, you mentioned cash for keys. This sounds different, like a deal.
It can be, yeah. It often comes up in no-fault eviction situations, like the owner move-in or substantial remodel we talk about.
So the landlord offers you money to move out quickly.
Basically, yes. They offer a financial incentive to bypass the formal eviction process and get you to vacate voluntarily.
Is that okay? What's the catch?
It can be legitimate, but the vital insight here is you need to know what you're actually entitled to before accepting an offer.
Entitled to?
Yes. Under state law or local ordinances, for many no-fault evictions, you're legally entitled to relocation assistance payment. Sometimes the cash for keys offer is less than that required payment. So you need to know your rights to relocation assistance first. Then you can negotiate fairly. It's a negotiation, remember, not a demand you have to accept.
Okay, that makes sense. Understand your baseline rights first.
Exactly.
Right.
So all these tactics, it raises the big question, like, what can you actually do if you're facing this stuff?
Sure.
Harassment, illegal notices, whatever it is.
Yeah, what's the playbook? Our sources lay out some concrete actions.
They do. And it's about being proactive.
So if you're in this situation listening right now, what does this mean for you? It means you can take action. You're not powerless.
Absolutely not.
So, expert, you mentioned documenting everything. What's the biggest mistake tenants make with documentation? And maybe a pro tip.
The biggest mistake is probably not being thorough enough, or just relying on phone calls, verbal promises, things you can't easily prove later.
Right. No paper trail.
Exactly. So the pro tip, document everything, like you're building a court case from day one. Because, well, you might need to.
Everything means.
Keep detailed records, dates, times, who you spoke to, what was said. Keep copies of all communications, texts, emails, formal letters. Take photos, videos of bad conditions or repairs needed. Date them.
So if Sarah emails her landlord about a leak,
She saves the email. If they talk on the phone, she follows up immediately with an email summarizing, "Hi, landlord. Confirming our call today where you agreed to fix the leak by Friday." Create that record.
that's a really practical tip. Okay, documentation first. Then you said understanding your rights. Legal stuff can feel so overwhelming, though. Where can people go for clear info?
Yeah, it can seem daunting, but there are actually really good user-friendly resources out there.
Like?
The California Courts Self-Help Guide website is excellent. Plain language, breaks things down. Also, the State Attorney General's Office website has a landlord-tenant section.
Okay, court website, AG website, good starting points.
Definitely. They're designed for regular people, like Sarah, to understand their rights without needing a law degree.
So you've documented, you understand your rights. What's next if the landlord isn't responding or the issue continues?
Then you need to communicate in writing formally.
Even if you've already emailed or texted.
Especially then. Send a formal, dated letter, certified mail is even better, clearly stating the problem, referencing your rights, and demanding a specific resolution by a certain date.
Why formal?
Because it creates an undeniable official record that you notify the landlord and try to resolve it. It shows you we're serious and followed procedure. Much stronger than just texts if things escalate.
Okay, formal letter. What if that doesn't work? Who does Sarah call next?
That's when you escalate outwards. Contact housing authorities.
Like the city housing department.
Exactly. Your local city or county housing department, rent control board if you have one, or tenant advocacy groups. They can often investigate complaints, mediate disputes, maybe even enforce local codes.
So they have some teeth.
They can, yes. And they provide guidance and support, which is huge when you feel alone in this.
When does it become time to call a lawyer? When should you seek legal assistance?
Honestly, the moment you receive a formal eviction notice, or if the harassment or illegal actions are serious and ongoing, or frankly, any time you feel overwhelmed and unsure how to proceed.
But lawyers are expensive, right?
That's a common concern, but don't let it stop you from inquiring. Many legal aid societies and nonprofits offer free or low-cost legal help, specifically for tenants, especially low-income tenants. It's worth looking into those options.
Okay, legal aid is out there. Now, this next point feels really fundamental, but maybe easy to forget under pressure. Refuse to leave without a court order. What's the absolute core message here?
The core message is simple but critical. You do not have to move out just because your landlord tells you to, or gives you a notice, or even turns off your water.
Really? Even if they shut things off?
Yes. Only a judge, through a formal court process called an unlawful detainer lawsuit, can issue an order legally forcing you to leave. Until that happens, you have the right to remain in your home. Don't let anyone pressure or trick you into leaving without that court order.
That's a powerful right to remember. Okay, finally, if you do get an eviction notice, what's one crucial first step? You mentioned no eviction defenses.
Read that notice very carefully. Critically, don't just panic.
Look for those mistakes you mentioned.
Exactly. Look for errors in dates, names, amounts, the reason given. Think about why they might be evicting you. Is it really because you were late with rent once? Or is it maybe retaliation because you asked for repairs last month? There are many potential legal defenses. Improper notice, retaliation, breach of the warranty of habitability, meaning the landlord failed to keep the place livable. An attorney is best placed to help you identify these, but just knowing defenses exist is important.
Okay. So connecting all these threads, it's clear you don't have to face this stuff alone.
Not at all. There's a whole system of support, resources. You just need to know where to look.
Right. This deep dive really drives home that knowing your rights is just the start. Knowing where to turn for help is just as vital. So for Sarah or anyone listening, what's a good first step to find that local support?
Search online for local tenant organizations or legal aid services in your specific city or county. These groups are gold. They know the local rules. They offer counseling, workshops, referrals.
Tenant unions too.
Tenant unions, advocacy groups, yes. And alongside that, try to understand the California eviction process itself. Knowing the basic steps, the timelines involved, it demystifies it a bit, makes it less scary if you do end up in court.
Knowledge is power, basically.
It truly is. Empowerment here really comes from knowing your rights and taking proactive steps using the available resources.
We have covered a ton today. From your basic rights, habitable home, privacy, to spotting those landlord tactics like harassment or illegal lockouts.
Retaliation, bad notices.
Right. And most importantly, the concrete steps you can actually take. Document everything.
Know your rights. Communicate formally.
Seek help from housing authorities or lawyers, and crucially, don't leave without that court order.
That's the core of it. The big takeaway is, tenants in California, you have significant legal protections. You really do.
It's about knowing them.
Knowing them, recognizing when they're being trampled on, and knowing how to respond effectively, that's how you safeguard your home and, honestly, your peace of mind.
So, to leave you with something to think about, a provocative thought, perhaps. We've talked about landlord tactics, but given how deep these tenant protections run, what surprising clause might be lurking? Not from the landlord directly, but maybe within your own lease agreement right now.
Ooh, that's interesting.
Or maybe a niche local ordinance you're completely unaware of, something that could subtly affect your rights, for better or worse. How can digging into those details proactively fortify your fundamental right to a safe and secure home, making sure you're truly prepared?
That's a great question for listeners to ponder.
We really encourage you to explore those local resources we mentioned, check your lease again with fresh eyes, and keep all these insights in mind.
Call now 714-442-9741. Thank you.